Wonderful. Good morning, everyone. Welcome to Florida Makes' webinar series. I am coming to you live from Orlando, Florida. Always good to be here at Florida Makes HQ in downtown Orlando. And we are so thrilled and honored to have with us today an esteemed group of folks who are experts in the field of intellectual property. And so those of you that need the reminder, this is a 90-minute webinar. So make sure that, that you will stay with us, have your caffeine, your tea, your coffee. It is 90 minutes of just awesome, wonderful content. So I will go ahead and start the introductions. I will make some comments about Florida Makes, and then I will introduce the head of the U.S. Patent and Trademark Office IP Attaché program to introduce the topic in her team. And then at the end of that, we will go ahead and have an interactive Q&A session. And that is and please, we encourage everybody. There's plenty of you in the webinar right now. Everybody's encouraged to type in your questions. You can put it in the chat is our preference. So put it in the chat as we go through the material. And so here we go. I'm going to go ahead and make some comments about Florida Makes. Next slide, please. Patricia, or am I moving the slide? Okay, here we go. Yes, so Florida Makes, we are your manufacturing extension partnership in the state of Florida. We are known as Florida Makes. Our mission is to improve the productivity and technological performance of Florida's manufacturing sector. It is our vision to be the recognized leader and voice for strengthening and advancing the economy of the manufacturing economy of Florida. That is the mission and vision of Florida Makes. And next slide, please. And how do we help our manufacturers in the state? And these are some 6 key bullets that we had prepared for you. Understand that we do cover a whole gamut of services to our manufacturers, but just to help you remember what we do, we help our companies with technology acceleration and innovation. We also help you with cybersecurity and intellectual property, which is what this session is about, is on intellectual property. We have more stuff coming on cyber. We just have a partnership with Cyber Florida, and that is upcoming. Supply chain is very important. We all felt that during COVID. We have a wonderful team that helps with supply chain optimization. And of course, you will not be an MEP without helping our manufacturers with their performance assessment and continuous improvement. We have a wonderful team behind that. And then workforce is an important portion of how our companies will grow, right? We need the workforce and a trained workforce, so we help with that as well. And finally, this is really where I come from. I come from the business growth and financial services sector of the whole entrepreneurial space. And we are here to help our founders and owners and investors make sure that the investment is secure and the business continues to grow. So that's how Florida Makes help our companies, manufacturers in the state of Florida. Next slide, please. Today's session, we hope that you will, these are our key takeaways. We hope that you will learn about a wonderful resource that many of us don't even know about. So let's all learn about the U.S. Patent and Trademark Office, the IP Attaché program under Debbie's leadership, and the services they provide. Number 2, we want to gain insight into how these IP attachés provide information to help the U.S. stakeholders enter foreign markets or conduct business abroad. There is a reason why these men and women are with us today. These are primarily our key trading partners for the state of Florida. And so that's why they are here. We had to help choose the areas that they represent. And then lastly, a third key takeaway is here, best practices on how to operate in key trade markets pertinent to Florida. Next slide, please. And so, like I said, we're excited to have Debbie's team with us today. A little story. Debbie and her team were here in May in Orlando with Donnie. Oh, Donnie, you will take a minute. I forgot. We'll have Patricia will have Donnie also say something for a minute. But Debbie and her team were here in May. We had such a wonderful experience. Donnie helped with that and heard some good feedback from his manufacturers. And so let's go ahead. Donnie, go ahead and say hello and say something about you and MACF, please.
Hey guys, I'm Donnie Casey, the Executive Director for the Manufacturers Association. I actually serve the Central Florida area for Florida Makes, and one of my roles is the Executive Director for the Manufacturers Association of Central Florida. I did, as Ruth mentioned, got an opportunity to see what Debbie put together and participate a little bit in that day, and several of my manufacturers were able to. We just had a little bit of short notice getting there, and we didn't have a recording, so. Having her back is a phenomenal opportunity. A lot of our manufacturers didn't realize that we had this type of support at the federal government from intellectual property perspective. So a lot of them were very excited to attend and hear and learn about this. So I'm excited that there's going to not only be today that my manufacturers can come and listen and learn, but they'll be able to go back and watch this recording again. And this, just keep in mind, this is only four of the countries that are represented here today, but there's a lot more than that. And hearing their perspective on doing business in these countries, you should always engage them if you're going to start to do business overseas and you're bringing a product over there that you're going to begin to sell. There's a process to go through, and these are the best in the business, and it's something that is supplied for us by federal government. And I feel that anybody watching this is truly going to gain something here today and learn a little bit. So I'll go ahead and step out of the way and let Debbie and her team take it from here. Or Ruth, you can do that.
Thank you, Donnie. Yeah, so Debbie, again, thank you for coming and making this happen for Florida Mix and the entire state of Florida. I will go ahead and let you bring this wonderful program to us. Take it away, Debbie. Thank you.
Great. Now, thank you so much, Ruth. Thank you again, Donnie. It's a pleasure working with you on this program. And I do have the pleasure of also having four attachés with us today. We've got Michael Mangenson, who's the IP counselor based in Beijing, China. We have Rachel Bay, who's the IP attaché for the European Union, based in Brussels. We have Claudia Rojas, who's the IP specialist for Mexico, Central America, and the Caribbean. And finally, we have John Kabeka, who's the IP counselor for South Asia. So my name is Deborah Lashley Johnson. I'm the acting director for the IP Attaché program at the USPTO, at the US Patent and Trademark Office. And I'm in the very fortunate position to work with 14 attachés on IP policy issues, programming, and training in the 11 countries in which they're posted to advance the IP priorities for the US government and for US industry and stakeholders like yourself. So as Ruth and Donnie mentioned, in May, some of the attachés and I met with your sector when we were holding meetings with stakeholders in Orlando. And it was great meeting you all, especially Ruth and Donnie and Ruth's organization, Florida Makes, and other industry representatives at that meeting in May. So again, thank you, Ruth. Thank you, Donnie, for organizing this webinar today. It's a pleasure to talk to you all, to re-engage on these issues and to have a deeper conversation on IP and the foreign markets for the manufacturing industry. We are one of the free resources at USPTO seeking to protect IP abroad, and that is our program called the IP Attaché program. The IP attachés are posted overseas to help U.S. entrepreneurs, inventors, creators, and businesses that are looking to enter into foreign markets or are already conducting business abroad. The IP attachés are diplomats with IP expertise posted in embassies and consulates overseas. So as I mentioned, we have 14 attachés in Western and Central Europe, Latin America, China, South Asia, Southeast Asia, the Middle East, Sub-Saharan Africa. And we have two in Geneva, Switzerland, working on multilateral issues with the World Trade Organization and with the World Intellectual Property Organization. The IP attachés provide information to U.S. stakeholders on how to navigate foreign IP laws and regulations, how foreign courts work, and how stakeholders can protect and enforce their IP rights abroad. To be clear, and this kind of came out in our conversations in May, the IP attachés do not file or register our U.S. stakeholders' patents or trademarks abroad. The IP attachés are there to help U.S. stakeholders to navigate complicated IP systems in countries in which they can take steps to obtain the protection and enforcement that they need. For example, many U.S. companies encounter legal obstacles when attempting to expand their businesses overseas. If a client's business is hindered by a foreign law or regulation in a specific country, an IP attaché may be able to help. One of the attaché's roles is to advocate for changes in policies and laws and regulations related to intellectual property that are advantageous to U.S. stakeholders. In turn, U.S. stakeholders can help attachés to better understand the legal and regulatory issues that they, as a stakeholder, are facing. So the attachés wish to hear about the specific challenges that U.S. businesses and practitioners face and to discuss with them how those solutions or next steps can come about. Illegal copying and theft, also known as counterfeiting and piracy, is another issue that the IP attachés encounter frequently. If a U.S. business is having difficulties with counterfeiting and piracy and is unable to enforce its IP rights in various countries, an attaché may be able to help educate host government officials on IP matters. This includes providing training to judges, prosecutors, patent and trademark examiners, customs officials, police officers, and policymakers. Such training can provide a better understanding of the U.S. government's experience with IP matters and increase awareness of accepted world standards and practices, which ultimately enhance the effectiveness of IP protection in a given country or region. Also, by training officials of a host country, issues that right holders may face may be alleviated or better understood. The IP Attaché program is really here to help. Happy to put more information about the IP Attaché program and how you may want to contact an individual IP Attaché. We have the 4 here today, but there are 10 others that you may want to come in contact. So I have a website that I can put in the chat if that's convenient. So you can directly contact these attachés. A couple of notes with respect to the contact list. We will have a new attaché for the Mercosur region. So that contact will change as well. Right now, it's just the IP specialist noted. And just to highlight, our 14th attaché will be going out to Johannesburg, South Africa in the new year. So that contact information will be updated as well. In terms of big picture on these issues, IP protection and enforcement are all issues that innovative companies and creative industries really need to care about. First, it's extremely important to protect the fruits of your innovation and creativity to prevent theft. IP theft is a real problem. I'm sure we're all aware and read the newspapers about a lot of the counterfeiting and piracy and trade secret theft that goes on. This can happen whether it's someone you know and you have a business relationship with and distributing and selling your products and services, or someone you don't know, but that person and entity is aware of your cutting edge product and or service and really wants to reap the benefits of your hard work. Second, IP is an important glue to any business. It really takes companies to the next commercial level. IP protection distinguishes a businesses from its competitors. It helps you stand out in the marketplace. It helps you secure funding from outside investors. And IP facilitates licensing arrangements and partnerships. And lastly, I just want to highlight, it's been a real pleasure to be a part of the IP Attaché program. I was once an attaché many years ago, and now I'm in the great position of working with our attachés. And really, the key to our success is collaboration. We collaborate within the USPTO, within the main commerce, our main agency, Department of Commerce. We work very closely with the interagency to ensure that our USG priorities are achieved. We collaborate, of course, very closely with the foreign governments in which we're working with daily. We're building those relationships and are seeing inroads and successes. And we collaborate with you all, with all of the stakeholders and the various forums, working together to build a clear path to address IP issues and concerns. And one of that important element in terms of reaching out to stakeholders is our outreach domestically. So this is a key component to our program, and we really thank you for the opportunity to discuss these issues with you today. So now I will turn it to Mike Mangelson, who is the IP counselor based in Beijing, China. Thank you.
Thank you, Debbie, and welcome from Beijing, China. I just want to thank Debbie and others for this opportunity. I think it's important just to start off. I'm hopeful that with the few minutes I have tonight that I can share with you some of the things that we are doing in China and maybe give you some ideas for how we can be a resource to you as you consider coming to China to do business, or maybe you're already in China and this will give you some ideas on how we can be a resource. I think it's important to know that despite everything we hear about China, it continues to be a large market with significant opportunities for our U.S. businesses. I think if you take a look at the business environment surveys that come out of the American Chamber of Commerce, U.S.-China Business Council, more than 80% of the companies that are doing business in China, U.S. businesses or U.S. companies, are profitable. So I think there are many opportunities still to be had in China, but there are also many challenges and new challenges that our companies are facing in China. And IP protection remains a top concern for U.S. companies doing business here. If you take a look at the top concerns in the surveys that come out, including the American Chamber of Commerce, IP has been in that list of the top 10 concerns for as long as these surveys have been going on for over 20 years. They are kind of moving down in that list, and I think that's more of a factor of geopolitical relationships, some of the increase in regulations, data protection regulations, cybersecurity, anti-espionage, and state secret laws that are coming out in China that are now kind of moving up on that list of concerns. But IP remains a top concern. And so that's why we have a dedicated team at the U.S. Patent and Trademark Office that is focused on improving the IP environment in China for the benefit of our rights holders. And this team includes my office in Beijing. I'm the IP counselor. I have a team with me in Beijing. We also have IP Attachés in Shanghai and in Guangzhou, and we have 9 IP lawyers at U.S. Patent and Trademark Office headquarters in Alexandria, Virginia, that also work on the China team. And then we have 5 locally trained IP lawyers in China here that work with me to help research laws and help understand what's going on in the IP realm here in China. All of our lawyers are experts in China IP law, and all of our China-based staff and most of the US-based staff are language proficient. We have lived and worked in China previously. I've been in and out of China for 40 years. I was a student back in the 80s in the university here, Nanjing University. This is my 15th year, I believe, in China, living in China. But our 5 China-based lawyers also, they're locally trained lawyers, and they specialize in specific areas of China IP law. Our primary mission is to protect and promote the IP interests of U.S. companies in China. And this includes working closely with U.S. businesses to protect and enforce their IP here in China. We also advise and coordinate with the U.S. government agencies and China counterparts to resolve IP issues and also to promote our IP policy here. and encourage effective IP protection and enforcement in China. So some of the things that we do, just mention, and again, I hope that we can be a resource. First and foremost is we work closely with our U.S. businesses to help them protect their IP in China and to enforce that IP. So we can be of a resource to you as you are considering the market. We are happy to hold consultations with you to talk about potential strategies and best practices, and maybe also help introduce you to service providers that can help you in protecting and enforcing your rights here. We also engage with PRC government counterparts and the courts to help secure reforms and improve the IP environment here in China. I just had 2 days of programs with the China National Intellectual Property Administration over the last 2 days. Finished up today, we had experts in from our headquarters in Alexandria, Virginia, who did 2 days of programming on the overlapping areas of IP protection for designs, whether it be the configuration of your product, the shape of that product, or the packaging. That type of design that you have for your product and your packaging is important to protect. And there are different ways that you can protect that in China as well as in the United States. We had experts kind of comparing and contrasting the two systems. And those programs were open also to the public. So a lot of what we do and what we try to do in our programming with our counterpart agencies in China is we also try to use those as opportunities to help educate our companies who are doing business here. We also just finished up programming last week with the State Administration for Market Regulation. They're responsible for enforcing IP rights in China. We had public programs on anti-counterfeiting, on protecting IP on the online environment and how to enforce against infringement online. And we also, just 2 weeks ago, we had federal district court judges from the United States in China. We took them to 4 different cities on a judicial exchange, holding exchanges with other judges here in China. We met with over 25 different judges to exchange information on how we adjudicate IP cases. So we feel like these are all important for our rights holders and improving the IP environment here in China. We also work with the trade associations here in China. And I was meeting with the American Chamber of Commerce earlier today. We had a roundtable event. Our China team educates rights holders on the risks and opportunities in China. And then we try to advocate on their behalf when that's possible and appropriate. For example, when there's cases of local protectionism in a court, we can step in and help advocate for our rights holders, participate in hearings, draw attention to those issues through correspondence and interaction with the Supreme People's Court. We also provide extensive training and programs and webinars to educate U.S. companies doing business here. We have held 36 in-person China IP roadshows across America. We just held one in Salt Lake City a couple of weeks ago. I think earlier this year we held one in Clearwater, Florida. But to the extent there is interest within Florida and your city to hold one of these roadshows, we're happy to consider that and come out and help you better understand how to protect your IP in China. These outreach efforts also give us a better understanding of the challenges that companies are facing here, which helps us kind of then develop our U.S. policy as it relates to China. So that's just a little bit about what the China team does. We do have a page, a site on our USPTO.gov website. If you search China IP at USPTO, you'd be able to find that, and it has a lot more resources that you can look at, and including we have a China IP toolkit that gives a lot of information that I won't be able to go over today. So why don't I just take a few minutes, talk about some of the top challenges that companies are facing in China. I think if you look at the most pervasive issue or challenge that companies have here, it probably starts with brand protection, both on the side of difficulties in protecting trademarks and then enforcing trademarks against counterfeiters. We do see a rise in counterfeiting, not just in China, but globally. And if you look at that statistics on where that is originating. A majority of that worldwide is originating from China. The customs CBP every year comes out with their statistics on seizures at the border of counterfeit products, and typically around 80% or more of their seizures each year are from China. And some of the reasons why this is a growing problem is that a lot of the counterfeiters are now shifting from e-commerce platforms and from hard markets to social commerce, live streaming platforms that have fewer systems in place to protect IP. They also try to avoid detection and avoid enforcement by shipping goods in small parcels with declared values that are below legal thresholds to avoid detection, both in China and also by US Customs. We find them also changing labels and packaging of the goods after shipment. So a lot of times they send the shipment of goods without the labels, without branding, and then they affix the branding, the fake labels to those goods after they've been shipped. They also are warehousing minimal inventories to avoid criminal enforcement thresholds in China. China often will base criminal enforcement on the amount of product that is seized. So oftentimes they have their inventories spread out in multiple locations. There's also, we found in talking to rights holders, a growing international syndication of Chinese counterfeiters that have extensive and sophisticated networks around the world. So these are issues that we're facing, and that, I think companies that are considering to do business in China need to take this into consideration and plan for that. We also see obstacles to safeguarding technologies. If you have a product that is protected by patents, and it's a product or a technology space that is targeted in one of China's industrial policies to basically develop and to dominate in the world, that could be a problem. We see difficulties in patenting those type of innovations. We also see many mandatory trade secret disclosure requirements in administrative and regulatory and judicial processes in China. That's one of the big issues that we're trying to work with China to fix. And that example of that is when you try to get your product approved to be sold in China, you have to go through a regulatory approval process, and oftentimes you're required to disclose trade secrets as part of that process without any controls on how those trade secrets are protected and what the regulatory agencies can do with that, including using third-party experts to evaluate that information. And oftentimes those third-party experts are competitors. I mentioned problems with trademark rights. One of the probably biggest problems that we have here is what we call bad faith trademarks, or trademark squatters, who will try to beat a right holder, a brand owner, to registering their trademark in China. And in China, the first entity that registers the mark in China has rights to that mark and can prevent even the legitimate brand owners from using their marks in China. And it's important for manufacturers, regardless, I think, of your business model. This is one of those areas I think is important to consider as you're looking at how you strategize the China market. And as you allocate resources to your IP, I think brand protection and registering trademarks has got to be at the top of that list, whether it be selling product into China or manufacturing in China for export. If someone has registered your trademark, they can prevent you even from exporting product out of the country with that brand. So something to also to keep into consideration. I think I want to just close with the last few minutes I have, maybe going over a few best practices to consider as you are looking at the China market. I think first it's important that you know what you have in terms of IP and what you will need in China to achieve your business strategy. So this includes conducting an IP audit and coordinating the IP analysis with your business planning. I think it's really crucial that the plan that you put together include key IP protections and that you put those in place before entering the marketplace, for example, registering your trademarks. It's also important, I think, to understand the alternative ways for protecting your technology and IP. And this starts by understanding the differences between the system in the United States and in China. Those systems for protecting IP are different. And the fact that you might have rights, a trademark, a patent registered in the United States does not automatically grant you protections in China. I think also in looking at China, it's important to create this basket of IP rights, including your patents, trade secrets, trademarks, and copyrights. Because if you have a multi-layered IP portfolio, this approach can help provide more of a synergistic protection and can often compensate for some of the gaps in China's IP system. Oftentimes, if you're not able to, for example, to protect a trademark, you can potentially have a copyright protection that would help you in that case. I think it's also important when you're developing your IP strategy to keep enforcement in mind. Oftentimes we talk about registering trademarks, registering patents, protecting your rights in that way. But you also, in China, it's probably a good chance that you're going to have to enforce those rights. And if you only have the IP and you're not willing or able to enforce those rights, it's not going to be of much value. So develop a strategy that involves hiring a competent local IP attorney that can provide a full range of services. These services should include more than just registering rights, but also monitoring, investigating, and enforcing your intellectual property. Customizing your strategy according to your needs and the potential risks. So, for example, your strategy may be different depending on the nature of your business and your IP rights and your plans for China. If you want to be successful in China, you need to consider and plan this carefully. For example, if you have cutting-edge technology that China is targeting, for example, advanced manufacturing processes, you need to consider whether or not you should even bring that to China if it's evident that you may not be able to protect it and you'd lose control over that process. And then I think finally consider that the decision to seek a patent for subject matter protected by trade secret may also have significant consequences. So one example is if a patent is sought but not obtained, or is granted and then invalidated in China, the subject matter may have become public. That means you can't protect that through trade secret. That's no longer available. So those are some high level, I think, best practices in China. And why don't I just mention a couple potential pitfalls, some of the mistakes that companies may make. I think one is relying on protection strategies in your home market. For example, in the United States, to protect your IP in China. We need to understand that the legal systems are different. So do your homework, and today is part of that homework in learning the differences between the two systems and the tools that you can be using for protecting your IP. I think also sometimes people think, well, China is a great place to make money, and so they allow the enthusiasm of making money in China mask some of the risks. So don't cut corners to save money, or because you trust your relationship, for example, that you have with a Chinese partner. And I think it's also important that you don't rely on a Chinese partner to protect your IP for you. There's a lot of companies that get in trouble because they have a falling out with a partner and they find that their IP is in the name of their partner and it's very difficult to get back. So maintain your ownership of those registrations within your company and don't allow your local distributor or business partner to arrange that for you. And then I think it's also important just finally to think that protecting IP through the registration of rights alone is sufficient. You really need to have a more holistic approach when you're looking at China. And I'll leave it at that. Appreciate the time. Thank you.
Thank you so much, Mike. This was super informative. A lot of interesting points for us to consider. And so as people are thinking through some of your the list that you provided, some of the top pitfalls, as well as best practices, let's move on to Rachel Bay, who's the IP Attaché for the European Union.
Thank you, Debbie. Hi, everyone. Really nice to be with you today. And my hello is from Brussels, Belgium, the land of chocolates and very strong beers. So I, as Debbie mentioned, cover the European Union and its 27 member states. I also cover Switzerland, Liechtenstein, Iceland, and Norway, and the United Kingdom. I have a staff of 2 lawyers here with me in Brussels, as well as we are in the process of hiring a 3rd lawyer to be based in Berlin, Germany. I do cover a large region, but I understand all of you are primarily interested in the United Kingdom, so I will narrow in my discussion to the UK. The good news is in the UK, they have actually a very strong IP protection and enforcement system. Mike mentioned earlier the US Chamber International IP Index. And in the 2024 index, the United Kingdom came in 2nd, only behind the US. And of course, it was ahead of France, Germany, Sweden, Japan, and Switzerland. So it does have a strong system. But of course, counterfeiting and piracy is a problem globally. And so it's really up to you to make sure, even within the strong IP protection and enforcement country, that you make sure that your intellectual property is protected. As you all know, the United Kingdom used to be a part of the European Union, but it left the EU back in 2020. Before you could register your intellectual property, specifically trademarks and designs, with the EU IP office. If you did that, you could obtain a unitary trademark protection, meaning it is protected throughout the EU, including the UK. But because the UK left, you would have to register your intellectual property for protection directly with the UK IP office. That said, the UK negotiated sort of a transition period, meaning that if your trademark was registered with the EU before 2021, then it would continue getting protection in the UK, but you would have to go through some administrative steps. You wouldn't have to pay for anything additional, but you would have to make sure that your trademark was protected within the UK and make sure that it was registered with the UK IP office. Anything that was registered after January 2021, you would have to directly register your trademark with the UK IP office for future protection in the UK. This also applies to what in the EU and the UK is called industrial designs. In the US, we call it design patents. But in order to have your design protected in the UK, you would have to register it directly with the UK IP office. In the UK, as you know, it has also independent Commonwealth states that it's associated with and territories such as Antigua, Bermuda, Bahamas, Bermuda, the British Virgin Islands, etc. And you could actually extend your trademark protection and design protection to those other territories. But there's specific information with the UK IPO on their website if you wanted to extend your trademark and design protection over to those countries. As the UK was a part of the EU for a very long time, of course, and it was obligated to abide by the EU laws. The UK actually, their systems are really similar to the EU systems. When it left the EU, they had to take another look at all of their laws to make sure what they wanted to keep and what they wanted to change. But on the whole, they kept everything. So if you are doing business in the EU, and you're familiar with the EU systems, the UK systems in large part remain the same. On the patent front, if you want protection for your patents in the UK, you of course register it with the European Patent Office. The European Patent Office is not an EU institution, so nothing has changed in that in the context of patents. You continue registering for protection of your patents with the European Patent Office, but as maybe some of you know, the EU adopted a new system called unitary patents, meaning if you apply for a unitary patent in the EU, it means that all of the EU participating countries, you can have protection for your patents in those countries. Because the UK is no longer a part of the EU, you cannot apply for a unitary patent that includes the UK. So you would just have to request patent protection through the EPO for the UK, as well as any of the other EU countries that you want protection for. While the UK is no longer a member of the EU, and so it doesn't have any obligation to follow EU legislation anymore. It, as I mentioned, has a lot of similar laws in place. Right now, there is discussion between the UK and the EU about the possibility of entering into a new agreement. Basically, the UK is interested in having a similar arrangement as countries like Norway and Switzerland and Iceland have with the EU. That is possibly being part of the same customs union and having other advantages that some of these countries have with a special arrangement with the EU. That said, because the UK left the EU, there's still a lot of bad blood. And I don't think the EU is really interested in giving any special privileges to the UK, but there is discussion that they're going to probably enter into a special agreement. So we're following that from my office and we'll see how that goes. As I mentioned earlier, the UK has a strong enforcement regime, meaning that their laws are strong and their enforcement agencies make IP protection a priority. But having said that, there's a continued growth of the movement of counterfeit goods. So Mike mentioned some of the trends, and so that's not any different in the UK either. Companies, counterfeiters are taking large counterfeit products, taking them apart, sending them through small consignments. So that's kind of a global trend. So that sending them through the small consignments, they're not easily detected. Another trend in the UK is that there's a growth of e-commerce, obviously, and then which means again that there's a growing flow of counterfeit goods and small consignments. There's also a growing trend of counterfeit products coming to the UK from Turkey. This is a case in the EU broadly as well. A lot of counterfeit products enter the UK and originate from Turkey, and that's also the case for the EU as well. Also, a growing trend is that the UK, because generally the UK is not viewed as a country where counterfeit goods originate. Counterfeiters from other countries such as China are sending their goods to the UK to be repackaged and then sending it on to the US market. So there have been more US enforcement agencies collaborating with UK enforcement agencies, trying to figure out what volume of counterfeit products are flowing through the UK and then ending in the US. So this is something that we and US enforcement agencies are tracking. In the UK, His Majesty's Revenue and Customs Service is the part of the UK government that develops border policies. They work closely with the UK Border Force, which is part of the UK Home Office. And it's the UK Border Force that enforces against counterfeit goods at the border. Because the UK, again, is not part of the EU, before you could record your intellectual property with the EU IP office so that the EU customs agencies, the various EU member state customs agencies can have information of your intellectual property and can enforce that right around the EU territories. Because the UK is no longer a part of that, now you have to apply directly with the UK Border Force if you want the UK Border Force to be vigilant of counterfeit products and the fact that your IP is protected. On just a word on transit shipments, similar to the EU, because enforcement agencies, what they want to focus on is goods that are intended for consumption in their domestic market. And so what UK Border Force focuses on is goods coming into the UK for consumption in the UK. That said, if you are aware of counterfeit products that are transiting through the UK, you can bring that to the attention of the UK Border Force, and they will be able to stop that. But when you do that, you also have to show that wherever those transiting goods are destined for, it also has to be an IP infringement in that country. So if it's a counterfeit good, generally that's going to be infringing in another country. But if that protected trademark that the goods are infringing on is not registered and protected in the destination country, then the UK Border Force won't do anything to ensure that to stop that transit shipment. So that's just an additional thought on in-transit shipments. Just a last word on collaboration. Mike mentioned collaboration. Debbie mentioned collaboration. We engage with the UK enforcement agencies as well as the UK IP office to exchange information on best practices, as well as if there are particular issues that our IP stakeholders are having in the UK. We do this through regular bilateral discussions with those agencies, as well as by organizing joint training programs. And we try to bring in some of our stakeholders, usually those who have had some issues connecting with the enforcement agency that they wanted to talk to, but haven't been able to get them to respond to them. And so we bring some of our IP stakeholders into some of our training programs so that they can make the contact with some of the UK officials, so that in future they have a name and telephone number and email address so that they can more easily get in touch with them if they need to. So as Debbie mentioned, the fact that we are in our region, meeting regularly with the officials and fostering relationships with them is really helpful, just to stay on top of any changing policies so that we can inform our US businesses on some of these changing policies, but also to help make the connections if there's a need, if there's some difficulty for them to get in touch with some of the host government agencies. So Debbie, with that, I'll stop.
Great. No, thank you, Rachel. That was extremely helpful to really understand just how the events with Brexit kind of affects the IP landscape for the UK. And then also kind of a lot of the issues that we're seeing in the papers with respect to transshipment, and just how those issues are being handled by the UK Customs Office. And then lastly, the collaborative role that your office has with the UK officials on these issues. So that was really, really helpful. Now we'll move on to Claudia Rojas, who's the IP specialist for Mexico, Central America, and the Caribbean. Thanks, Claudia.
Thank you, Debbie, and good morning, everyone. I'd first like to thank Florida Markets representatives for this opportunity. I am the IP legal specialist for Mexico, Central America, and the Caribbean. And I like to spend this time speaking about IP advice on Mexico and mitigating risks when you think of exporting to Mexico. So, as you know, Mexico is one of the major trading partners of the USA, and there are significant number of business, trade, and investment ties between both countries. The first advice I would give you is that it is important to have an overall strategy to protect your intellectual property rights in Mexico. So Mexico is a country based on registrations. Protection of patents and trademarks is on a first in time, first in right basis. I must point out that the US has a first to use system. So you should consider applying for trademark and patent protection even before selling your products or services in the Mexico market. I think that it is vital for companies to understand that intellectual property is primarily a private right, and that the US government generally cannot enforce rights for private individuals in Mexico. So it is each of your responsibility, is the responsibility of each of you as right holders to register, to protect, and to enforce your rights, and whenever relevant, retain counsel, IP experts, and advisors. Honestly, companies may wish to seek advice from local attorneys or IP consultants who are experts in Mexican law. And this is where we come in, because we can direct you to IP associations here in Mexico, as a Mexican Association for the Protection of Intellectual Property, or other associations as well in the region. I'm referring to Central America and the Caribbean if there's interest in exporting there. So IP rights are handled a bit differently in Mexico than in the United States. Trademarks and patents are protected territorially. They are registered at a federal level and cover the entire territory. So different than in the US, there are no state registrations. So you may now ask yourselves, where are trademarks registered in Mexico? It is the Mexican Institute of Intellectual Property, or INPI, the federal agency in charge of receiving and examining applications, issuing or rejecting registrations, and deciding certain litigations proceedings. So yes, litigations does start at the INPI level, which just as a fact, it is an administrative agency. You may wonder about fees and applications. INPI's applications fees for a trademark for a trademark registration. To give you an idea, right now it's about $125 US. If you're thinking of requesting protection for your patent, that filing application is around $228 US. So INPI applications must be paid before filing the applications. A registered mark can be filed and then renewed indefinitely for 10-year periods, and a patent has a 20-year period. So again, you should always think of looking into the market and registering your trademark with the adequate counsel before going into the market. Do you need a representative to manage your intellectual property rights in Mexico? I would say yes, definitely. And especially if you do not have an address in Mexico, because when it comes to paying these filing fees, you are definitely going to be requested to have an address. So that is where your local advisor, your local IP representative comes into place. So yes, your registration is valid for 10 years, but there is an obligation to use your trademark within 3 years from registration. So in Mexico, registrants must now file a declaration of continued use within the first 3 years following the registration date. The registration will lapse automatically if the declaration is not filed, and a declaration of use must be submitted alongside each application when you decide to renew your trademark. This is very important. This is very important to keep in mind, that you don't only, you can't just keep confident that you have your trademark registered in Mexico and that you're going to be good for all during your 10 years. No, you should always be mindful to be using your trademark in Mexico within that 3-year period, in order for you to be able to prove and to submit this declaration of use. Again, of course, your attorney in-house is going to be, or in place is going to be taking care of that, of those procedures, but just be mindful of that. When we talk about the protection of IP rights in Mexico, I'd like to mention that there are several agencies that take an important role here. So, as I mentioned, the INPI, Mexican Institute of Industrial Property. I think I might have said intellectual at the beginning, but no, it's basically industrial property. The National Institute of Copyright. Also, the General Attorney's Office plays an important role in enforcing your rights. The Mexican Customs Agency, ANAM. The Federal Commission for the Protection Against Sanitary Risks, when you think about your patents, also plays an important role. The Consumers Bureau, and of course, if you happen to go into a litigation matter, always not only civil courts, but also a specialized IP court will come into play. And these are so some of the agencies that handle IP rights in Mexico. What are some of the challenges that we are seeing? Well, there is lack of coordination between domestic authorities, so that brings a challenge. There's been throughout the administrations, there's been reductions on the government's budget to combat counterfeiting. The litigation processes are very long and very complex. You don't want to get into that because I've seen cases where, well, a litigation process can take over 10 years. And we all know that there is a lack of consumer education and a lack of control from the authorities over markets, over flea markets, and other similar establishments where counterfeited products are clearly commercialized in Mexico. So yes, you do want to protect your products, and you don't want infringers counterfeiting your products. It is always recommended that if you have distributors here and you have a negotiation with distributors here, that you look into granting powers of attorney to them, because we've had cases when some of the distributors take over the market in Mexico, and then probably you as the owner of the trademark might forget about renewing it, and then your distributor, which might have had power of attorney or is a legal representative, might renew the your IP, your trademark, your patent, your industrial design under their name. So you may want to be really cautious about who you are doing business with, specifically, well, the distributors. Important to let you know that also before you go into the country and before you register your trademark, your patent, you should also know that customs has a trademark registration system. Customs, as I mentioned, the Mexican Customs Agency, ANAM, has a free database, and it integrates information that is voluntarily provided by the owners of registered trademarks in Mexico. And its purpose is to provide customs with reliable information about brands, expedite the clearance of goods, and identify potential irregularities in intellectual property matters. So this customs trademark base is linked to the trademark base of the Mexican Institute of Protection of Industrial Property. So they always look into the trademark or the entering products. They make sure that a trademark is registered when they are looking at your products, but maybe products or merchandise that don't look original. So they are going, customs is going, and the customs officials at the border are going to look into their database. And again, this coincides with INPI's database. So this might be a shield for you and something to take into consideration. Those are some of the keys that I wanted to highlight. So please look into the market when coming into Mexico, being mindful that the counterfeits and products are well spread all over Mexico. Also note that, yes, there are a lot of potential risks, but there are also big opportunities if you do take the time to shield your products, your brands, your patents. We are here to, and please use us as a resource. We are here to give you advice as to who to contact. And well, I hope that helps. And just keeping in the interest of time, I like to end my remarks there. Thank you.
Thank you so much, Claudia. That's super helpful. I think you highlighted a lot of key, sometimes overlooked issues when entering the market in Mexico. So it's helpful to bring some of that stuff to the forefront of people's minds. And also to reassure people about the really good work and effort in terms of the information you have with respect to navigating the IP system in Mexico. So thank you for that. Look forward to any further questions when we get to that segment of the webinar. And now we'll move on to John Kabeka, who's the IP counselor for South Asia. John.
Okay, hopefully you can all hear me. Again, good morning, good evening, everyone. I'm John Kabeka. I'm based at the US Embassy in New Delhi, India, and cover 8 countries throughout South Asia. So in addition to India, I support IP policy efforts in Afghanistan, Pakistan, Bhutan, Nepal, Bangladesh, Sri Lanka, and the Maldives. I've been here now, I've been with the USPTO now over 35 years and have been here in South Asia for almost 5 years. And the nice thing about going last is I basically get to say ditto to a lot of what my colleagues said from around the world, because there is a lot of overlap in the types of issues that we're seeing in our respective regions. But that said, I will highlight some of the things that I've seen and some of the things that I think would be really helpful for manufacturers that are looking to enter. And I'll focus primarily on India, but if you have questions on other markets, I'm happy to talk about those as well. And first, I'll just share that since my arrival, just within the past couple of years, India appointed a new head of their IP office. And it's actually the first time the head of the intellectual property office was, and it was brilliant, was actually an IP law professional, which is something that has made tremendous inroads in the progress that the Indian IP office has taken in just the short amount of 2.5 years now. So that's been a pleasure to work with and to see some improvements, particularly in the area of patents. And there's been some recent rules that have been released. One of them, and one thing you should all be aware if you are seeking patent protection in India, is to know that there is this Form 27 that used to be required every year, but now is required every 3 years. And it's basically a working statement where you have to certify whether or not you're working your patent. And this has a slew of concerns for industries that have to sign this form. And I probably don't have time to get into that, but I do think it's important that if you don't fill out the form, you could be subject to losing your patent rights in India. One thing I did want to share, just a quick story, because I recently had a meeting from a US manufacturing company that reached out to me, and this was their story. I won't share the name, obviously, but they had a relatively large manufacturing product, and someone in India purchased this product, and lo and behold, what ended up happening was that the Indian company that purchased it just completely reverse engineered it and started marketing it in India at a much lower cost than was available from this rights holder. And they had lots of patents in the US to cover this product, but none in India. And as a result of that, they really had very little recourse in seeking any action against this entity. And so I do think it's to be very careful if you are looking to even export your products to India. It does help to have IP protection here. If you do want to establish a presence in India, there is a requirement in India that requires you to have an Indian company as a partner. This is something that, as part of India's Make in India regime, they welcome foreign companies to come into India, but they must have a Indian company. And this is one thing that that I've also heard from companies. Sometimes this works really well, and sometimes that Indian company has, once they had access to perhaps the company's trade secrets, method of manufacture, know-how, were able to also spin off another company and become a competitor for the U.S. company. So that is a problem, obviously, and it is something that through the Foreign Commercial Service, there is a service that the Foreign Commercial Service provides that you can do background checks on potential partners, and my word of advice there is to do as much research as possible in finding your Indian partner. Many of them are very successful, but because of my role here, I always hear about the problems. I don't hear a lot about the successes. So that's just one thing I wanted to make sure to share. The other thing I'd like to highlight is there are a lot of US-India organizations that if you're not a partner of, you might want to consider becoming a partner. We have the US-India Business Council, the US-India Strategic Partnership Forum. There's also AmCham and a bunch of industry-focused organizations that have presence in India as well. And they're a good resource, especially, again, if you're looking for a manufacturing partner or to be able to sell your products in India. All of that, those are good contacts and resources in addition to having that background check done through our Foreign Commercial Service. Let me before I leave patents, I'll just share a couple years ago, India used to have an appeal process. So if you were, going back, if you filed your patent application and you were in disagreement, the examiner said it was not patentable, you thought it was patentable, the appeal, much like the Patent Trial and Appeal Board and the Trademark Trial and Appeal Board, would, within the USPTO, would take on that. But in India, that Intellectual Property Appellate Board was just abolished overnight. And so what ended up happening was all of those cases that would normally go to this interim tribunal now go directly to the High Court of India in the respective jurisdiction. Most of those go to the Delhi High Court. So the Delhi High Court created an intellectual property division. And that intellectual property division has been exceptional, very pro-innovator, very pro-patentee, and many of their decisions have really helped to change the landscape of dealing with the courts in India. But that said, it also highlighted some long-standing issues in the IP office, again, prior to the new head of the IP office coming on board, but that showed some maybe overreach by examiners. And so a lot of the cases that are coming out of the IPAB are actually accompanied by orders back to the IP office to come up with mechanisms to improve their systems, to improve their operations, and to make sure some of the basics issues are not happening that they're seeing in the courts. And so I do think the Intellectual Property Appellate Board was a good step. There's now 3 states within India that have IPABs. We're hoping one more will open in the next couple of months. But not IPAB, sorry, the Intellectual Property Division within the High Court. We're hoping another one will open in the next few months, and they are responsible for both trademark and copyright as well as patent appeals. Let me turn to trademarks. I think this is really important because generally getting a trademark in India is very quick. And that kind of is a blessing and a curse because it's so fast that there are questions as to the quality of examination. And we've seen that by a tremendous rise in trademark oppositions. So while you may get your trademark very quickly, someone with a very similar, perhaps a likely confusing mark might also get a trademark very quickly in the same field of use. So it ends up having you have to file a opposition proceeding, and those opposition proceedings there's a tremendous backlog. There's hundreds of thousands of applications in that backlog. Some have been pending for many years, and the Intellectual Property Division is trying to work through them as fast as they can, but at the same time, the backlog appears. What I heard recently from one of the High Court judges is they're no longer adding to the backlog. So they're starting to work their way into this backlog, which is a good sign, but it's still a situation you don't want to see yourself end up in. And then kind of going back to trademarks, and there is the fake markets throughout India with counterfeit products is quite prevalent. There is and I haven't seen it personally, but there are apparently different scales of copyrights, of counterfeits. So there's copy 1, which is like the best quality copy counterfeit. There's copy 2, and then copy 3, which would be like the cheapest and lowest quality. So it is that prevalent that everyone in India knows copy 1, copy 2, copy 3. And so getting enforcement actions on a large market that's selling counterfeit products in India can be challenging because first you have to take it to the IP office, and there has to be a decision by the head of the IP office on determining that yes, the mark is likely likely infringing your mark, and then you can take a police action to do a seizure and things like that. And what ends up happening is the counterfeiter gets word of this taking place, and then by the time the seizure occurs, there's no products in the warehouse. And so to circumvent that, for those brands that also have, for your logos, for your trademarks, that also have some artistic qualities to it, perhaps a design element within the logo, what we have found is stakeholders have had more success instead of filing a trademark case as they file a copyright infringement case, and they get much quicker decisions by the court. They don't have to go to the Copyright Office to make a determination, and interim injunctions are quite easy to do. So that is one workaround I think is worth noting. And then, I realize we're kind of running out of time. So again, happy to take questions, but I will take just a moment to share that some of the programs that we've done just within the past few months is, I have one more thing to talk to you about, and I'll get right to that. But just to talk about the programs is, we did several patent programs, not just with the Indian Patent Office, but with other IP offices throughout the region. We just did a regional trademark and geographic indications program with all of the countries in South Asia. Similarly, we've done customs programs with my counterpart in Bangkok, the counterpart IP Attaché that's based in Bangkok to cover South and Southeast Asia. And then just last March, we did a program with all of the high courts within India, as well as high court and Supreme Court justices from throughout South Asia, as well as justices from the US, for a 3-day conclave to talk about the current issues that the courts are facing, both in trademark infringement, fraudulent online marketplaces, patent standards, especially standard essential patents, and a slew of them. One topic was specifically focused on trade secrets, and that's the one thing I wanted to leave you with, is if you have any trade secrets in your manufacturing process that are not in the public domain, India does not have a simplified trade secret mechanism. They have this patchwork of very kind of nuanced laws that together, they use to cover the protection of confidential business information, but there's nothing really there to cover misappropriation, theft of that trade secret. And having this hodgepodge of laws, when I talk to high court justices, they say it is ripe for misinterpretation and creates uncertainty in the system. So as if you enter the Indian market, please take steps to secure your trade secrets and make sure that you're being very careful as to who has access to your trade secret information. All of that said, I will just close by saying it is still an extremely attractive market here. The Indian, India generally is a pleasure to work with. Generally, things are going to go well, but at the same time, there is this risk that you have to weigh. And again, if you do your homework, hopefully those risks can be mitigated. So again, thank you very much and look forward to any questions you may have.
Thank you, John. Thank you so much. Again, that was extremely helpful in terms of just your thoughts on navigating the IP system in India and the important ongoing work that we're doing to improve the IP system there as well. So Ruth, maybe I should kick it back to you to see if we have any questions or comments from the audience.
Absolutely. Yeah. So, okay, good. Hi, everyone. Wow, thank you so much to Debbie and her team of IP experts. I was taking copious notes, and one thing that came to me is just, I'm glad we're doing this because there's so many different considerations, really, depending on the country that you're looking at. And folks, those of you who are staying with us with this 90 minutes, thank you so much, because these are our primary trading partners, and they only just scratched the surface. So we do have some questions, but first of all, I want to mention that Thomas Morrison, who's part of Debbie's team, has been posting some links in the chat and the Q&A, so make sure you all capture that. And Debbie also posted her information in the chat. So I will go ahead and ask just some questions that came to us. Let's see. I think many of you already answered this, so I'm going to do a two-part question. And thank you all again for such a wonderful presentation and information sharing. So if there was one piece of advice that you would give to a manufacturing company, let's focus our comment on not consumer goods, but John, your story there about that big equipment spoke to me, because that is our clients. Reverse engineering is a big concern. So what is the one piece of advice that you all would give to a manufacturing company seeking to do business abroad? And then I'm going to add on another question is, when is the best time to be doing their research and due diligence on IP? Debbie, you want to go ahead and moderate who goes first, or?
Sure, and I could maybe start, and of course the attachés could add on to that. Just to take the last question first, in terms of starting to do their research early and often, and reaching out to us would be really important in that search and in that understanding. Mike mentioned doing an audit and an inventory of the intellectual property you would have. I can absolutely second that. There is a tool that the USPTO has. It's called the IP identifier. And I could also, either I or Thomas can put that on the chat as well. That's really super important for a lot of companies who may not be steeped on IP issues to really figure out what intellectual property they have. And it's a series of questions just to kind of go through those issues. It's a whole webinar in and of itself about patents and trademarks and copyrights and trade secrets and all of the enforcement provisions that we have in the US. But then when you start thinking about all of the various markets that the attachés are posted in, that's a multi-day webinar. But the IP identifier is really a good start, just figuring out what you have here that can be protected, and then looking abroad. Another important link, the IP Attachés work very closely with the Office of Policy and International Affairs. That is my home business unit in USPTO, and we have a team of lawyers here at headquarters who support the attachés and do a lot of the programming and the legislative analysis as well. So this is a multi-prong kind of approach the USPTO takes with respect to helping U.S. stakeholders and making them better aware of the IP that they have. But I will now kick it off to Mike to provide further detail to those two questions that Ruth posed.
So from the China perspective, yeah, I think that probably the most important advice that I can give you to focus on first would be, as you're developing that plan and how you allocate your resources for protecting your IP in China. And of course, as Debbie mentioned, you do this as soon as you can. I would probably focus on protecting your trademark rights in China. Every company will have branding rights or trademark rights, regardless of what business you're in. And I see so many companies that face this issue in China. In fact, I think nearly all of the companies that have been doing business in China, if they haven't taken steps to protect their trademark rights by registering, are facing the problem of squatters who have gone in and then registered those marks, and now they're almost impossible to get back. So I would allocate resources to that. Trademarks are less expensive than patents. I understand, especially small companies, that IP can be expensive. And so that's what I would focus on. And then I saw there was another question. I don't know if we want to ask. There was one specific for China. It's related to this, so I'll just answer it right now. There's a question that someone asked about a large competitor in China who's infringing their utility model or utility patent, I guess, and then this company's filed in a suit against the company in the United States. The China piece, and it's a small company, it sounds like, the China piece for patents and patent enforcement, I would definitely look at, and we can help with the resources on this, but most likely you do have counsel helping you with your China patent enforcement case. But I would definitely take a look at administrative enforcement, because this is something that we don't do. We don't enforce patents against infringers at the U.S. Patent and Trademark Office, but China, this IP office does, and they will handle. They will investigate. They will basically take a lot of the burden on if you're able to show a prima facie case, and it's a lot less expensive. So that's something to consider from the China side. And the U.S. side, when you have someone filing a lawsuit against you, now I probably be more concerned about that, because the expense of defending that type of litigation is a lot higher. If it's filed in bad faith, there might be some things you can do. You may even be able to. China is now cracking down on bad faith filings in both on the patent side and trademarks in China now. So there might be some things we could do there as well if it's shown that this infringer is kind of harassing you in bad faith. So that's my thoughts on that question.
Great. Any other comments or
Maybe
additional insights? Mm-hmm.
I can just add, I obviously agree with everything Debbie said in terms of if you should look at create an IP strategy, do your research as early as possible. And I just to sort of share with you some experience that I've had when businesses contacted me. There were a couple of US businesses just doing business in the US, no interest or hadn't even really thought about doing business abroad, found out that somebody had registered their trademark in one of the EU countries. So basically, working off of the success of the US business in the US and basically passing off their product as if it's related to the US product and US company. So that just to say, even if you're not looking to do business abroad, others will look to, because US businesses are known to be generally very dynamic. A lot of US business products are well thought of around the world. And so there are trolls basically looking to what's working in the US and then, registering the IP in other countries, including in Europe, which is why it's really highly advised that you do your assessment of what intellectual property is in your business and create a strategy before you think about going abroad. But even if you're not even thinking about going abroad, it would really be useful. I've also, the online environment is a big challenge, I think, for a lot of businesses. I had a situation where a US business said that their product was being marketed on a UK website, and they were not doing business in the UK. Turned out there was a Chinese entity that had registered their trademark on this UK website, and they wanted to know what they could do. Usually when there is a problem like that, because they weren't thinking about doing business in the UK, they hadn't registered and gotten protection for their IP in the UK, it's too late. Again, reason why you really should think about doing the IP assessment for your business, think about your strategy and act accordingly. Also, super important to do research on whoever you might be thinking of going into business with. We have US embassies around the world, and sometimes our Foreign Commercial Service representatives can help you as you do your research on potential business partners.
Those are all really good tips. Thank you, Rachel. Any other insights?
I do.
Okay, great, Claudia.
Thanks. So I wanna say I echo what Rachel and Mike have said, but I also wanna add, do a trademark search before you go into the country. So in the webpage of the Mexican Institute of Industrial Property, doing a trademark search is pretty easy. Sometimes you will be surprised, amazed of how many confusingly similar trademarks to your trademark you might find. So that's one. You can reach out to me and tell me, how do I do that? And I can help without a problem. And then I would say, think as an infringer does, meaning you make it, we fake it. That's a phrase that really sticks to my head. Also, you're gonna be surprised and not only think about the design of your trademark, but also about your trade dress. We found well, many trade dress examples I can think of, but donuts, and there's a famous bakery in Washington, the Cupcake Factory, I believe. So there was one in Guadalajara, Mexico, and they copied everything, not only the trademark, but all the shop, the trade dress, the napkins, the design of the shop per se. So just do a trademark search. Again, know and the third one, know who your competitors are. So just get out there and do this research, but do it before going into the market, and protect your IP, really protect it before starting to sell. And I'll stop there.
Thanks, Claudia.
Sure.
All really practical points there.
Yeah.
Sure.
We are over time, ladies and gentlemen. This is wonderful. We allocated 90 minutes. I guess we could have gone on. There is a pending question on Vietnam. I will get with you on that one. Let me get some answer from Debbie on Vietnam. And then Dan Baruz, I will contact you so we can provide you additional resources on that as well. So I just want to wrap up because we want to respect everybody's time. And some key takeaways, I think we checked off all of those. I don't need to rehash them. Everybody did a wonderful job sharing so much insight into each individual region and country as far as intellectual property. I think we all need to rehash what's the difference between trademark, copyright, and patent, but these were all very, very useful. The recording will be sent to you afterwards. Feel free to share. And a final reminder to all our manufacturers in Florida, you will hear from your local business advisor to follow up with you, make sure that you are getting the resources from Florida Makes. And then again, you will hear from me on this topic and anything else. Debbie, any final words from you, ma'am?
Just to say, I'm so happy to be a part of this. Thank you again, Ruth. I wish we could do this every week. If I was queen of the world, I would do it every week. So I really do love the creativity and having this webcast and put on your YouTube channel so manufacturers in your area can and elsewhere can really take advantage of this information. Regarding the manufacturing in Vietnam, a really good question. Wish I could have all the attachés with me today. Matt Koner is our attaché for Southeast Asia. So I did put a link in the chat. Hopefully you can see that. I can also copy it, move it on to the Q&A section for his contact details. He has his thumb and the pulse of what's going on in Vietnam. My general impression is that, you know, enforcement and counterfeiting and piracy is particularly in that part of the world, is a growing problem. It's a serious problem. We do have really good relationships, though, with the government in Vietnam and doing a lot of important key programming. So while there are challenges, I think there are great opportunities there, particularly our trade relationship with Vietnam. So don't want to paint a bleak picture, but just like with the other comments that have been made today, some serious issues, but with our attachés and with various IP agencies looking at these issues, we do have a lot of great inroads. So happy to follow up on any particular questions on any particular regions for the participants today. Thank you.
Thank you. Thank you, Debbie. Thank you, everyone, again, and for joining us in different time zones, different parts of the world, and all the manufacturers and partners. This is Ruth Buchanan signing off from Florida Makes. Everybody have a wonderful weekend. Thank you. Bye-bye.
Thank you.